Nsem-Pii TV nie.
Good morning. I'm Makwa Babiem at the Nsem-Pii TV platform so. Damasi se mo agibre na bibia mutie. Na no pay justice if you say wasari butwi na watin simbia ama ayamhihie kakra aba regarding a ruling ahodo any nsem a oditudwa ewo the criminal division of the Accra High Court. Na the ama sansemi ayehu kakra ni se nipa odi sansemi betudwa no emranim ni a wawedare ewo mranim yipa enyina yini lawyer na Nigeria Baffour ewua. Yes, ono ne di napo anim in his defamation suit against Nsem-Pii. Ebua Nsem-Pii for a bonica ema nkotua ema napo. Ono a ene se ginemu edema second lady Samira Bawumia ema ni issue strong warning says Nsem-Pii antwe nsem bia ansan a ode ne ba kopie mu court. Na ono anso na emra ho nsem bia ba ode kosi essential so mpempi no ya obi ni oman hene etai frɛ no mane di nkyirimu emu da hɔ ebre oman Ghana fo na no a Paul Adomokyere eton safrɛ no ewo good evening Ghana show so na nkomodidie ne koso no na Paul Adomokyere busa no toro Nsem-Pii die sɛ amene se atoni gina recuse no ho ana no kuri bia nima odi nkyirimu bai eno na lawyer na Nigeria Baffour kasa bi no se Paul se me de wo kɔ Ghana mramu a ade na justice efiase wasare botu ye no it was unconstitutional. It is against the Constitution of Ghana. Say Attorney General or prosecutorial responsibilities any power no. The justice of the Court of Appeal ebe bien no akasa same way e wo court hono. Asem no kokopie mu Supreme Court and hwe yi a ebetimi e de asem aba. Okansa same way Paul Adomokyere yam hyi ni yipa ebusa ne se sade a onhye chini mu na wonte asie. Nkyiremu ni nie etifo ebesere
There shall 881 reads, there shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to the government.
Yes, Attorney General shall be Minister of State and the principal legal advisor to the government. 883, please.
So 883 says, the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offences.
Wow, that's heavy.
You understand?
Read that again, 883. The Attorney General shall be what?
Shall be responsible for the initiation and conduct of all prosecutions of criminal offences.
It means the judge's advice is actually unconstitutional.
Yeah, so because it's a Paul.
Initiation and conduct.
By the Attorney General.
That's detailed.
By the
that he shall be responsible to initiate it and to conduct it.
That's right. That's right.
Wow.
That's right.
Wow.
And so that advice is problematic. Right? So that is why I think that whole tape should not have been admitted.
But admitting it now helps her to come to the conclusion that the biggest allegation that the NDC made or the accused persons made against the Attorney General was that he was trying to manipulate the evidence to nail Attoforsen and was trying to cajole the third accused. And the judge says that's non-existent.
Let's do a small exercise. The judge came to the conclusion that from the record, the third accused had not said anything, right, against anything negative or detrimental to the interest of Mr. Attoforsen in the matter. Is that not what the judge said? From the record.
Yeah.
Now, what then that shows, right, is that the judge was able to determine the matter before her, the application before her, without listening to the tape.
It's vindication.
Yes.
Yeah.
Because the whole point about mistrial is that I am being influenced to testify against Mr. Attoforsen. The man who is making that allegation is done with his evidence in chief.
So there's no opportunity.
There's no opportunity.
Even if you are being influenced at this stage, there's no opportunity to come and implement that influence.
And you see, that conversation predates and per the judge's own ruling goes beyond the time when the judge determined that he has a case to answer. Now you have gone into the witness box and you have testified, giving your evidence in chief. The evidence in chief is your account, your personal account of events.
Yeah.
So you've gone into the witness box and testified. right? Now, you are following that testimony in the course of the cross-examination by Mr. Attoforson's lawyer. There's a point that most of us are missing. The cross-examination by Mr. Attoforson's lawyer of Japa is the same as his witness evidence in chief.
Yeah, because they're on the same side.
Exactly. Their interests
I said the same.
are the same. Now, this man, in all this, up until when, and even when, he made that ranting of the allegation that the AG called him, giving him pressure to testify against Mr. Attoforson and so on and so forth, had not said anything against Attoforson.
No.
And so, that allegation, right, even if true, on record, there is nothing of the sort that had happened. And so, if you are going for mistrial, why are you going for mistrial?
So that you are saying that the judge was able to come to the conclusion that mistrial does not apply without the tape.
Without the tape.
He was able to come to the conclusion of stay of proceedings without the tape.
Without the tape.
He was able to come to the conclusion of injuncting the Attorney General's
Without the tape.
So why the tape?
Why the tape?
I get your point. I get it. But for us, political journalists, we are interested in knowing what the judge thinks about the tape.
I am also interested.
Yeah.
And I think that...
And she has done justice to us.
Yes.
To the general public.
Yes.
By indicating that
because
she has heard the
because
tape.
there is a public interest in
Yes,
it.
high public interest.
But wait,
very high.
But wait. The damage, however, is that now the question is the tape gospel?
She hadn't even evaluated that.
Exactly.
She hadn't asked the Attorney General that, is that you? Did you have that conversation?
Exactly.
He hasn't been given a hearing.
Exactly.
So that's maybe unfair.
But now she's giving an advice based on that.
Yeah, I get it. Yes, that may actually be unfair. I mean, I don't know whether the Attorney General was called in chambers by the judge, and we don't know that yet. Maybe that happened.
But subject to further information, I am saying that it's unfair.
It appears unfair on the face of it.
Because now, the tape will now be sent to the appropriate forum if it becomes necessary. What happens if that forum, right, a proper scrutiny is done? Proper scrutiny is done. And they disagree, right? Or they find that they find that
it's either doctored,
and so on and so forth.
Like that.
And they take a different view
from
the judge.
A forensic person comes to look at it, and they take a different view from the judge, as you're saying.
And don't forget, that forum will always be inferior to the High Court.
Yes, absolutely.
And so what happens? And these are the reasons why I think we should have been,
a very interesting,
we should have been cautious in admitting the tape.
A very interesting analysis that you are bringing.
Sometimes...
I hope you are getting text messages on some of these things. So let's get ready. But lawyer, if the people have brought an application and the application hinges on the tape, if you don't admit the tape, so you are dismissing their application without looking at the evidence they brought?
No, you see, invariably, the tape did not contribute to the judge's decision. The judge did not decide to dismiss the application because of the evidence contained on the tape.
On the mistrial, it would appear she did. Because she went in and
said...
On
the mistrial, she basically said that no legislation gives her the power.
Yes, she said that.
No legislation gives her the power to interfere with the Attorney General's power to prosecute.
She said that. But why was she listening to it 10 times?
That is the point. That, for me, is the point. You understand? And so, one, it was no material for the determination of the application. And two, the Attorney General was not up for trial. It was not a criminal matter.
In this sense, the Attorney General is kind of up for trial because the application is against him.
But it is not a trial.
It may not be a trial, but he's the one who now has to present a defense.
But you see, the exceptions.
So you think she shouldn't have admitted the tape?
I don't think it was necessary.
But is it not better for the confidence in the justice system that she did?
Yes. It was good, for the confidence of the justice system.
Yes.
But she is, you see, when it comes to the practice of law, right, justice delivery in our country is done in accordance with set principles, right? When you look at the case of Harley versus Edra Farms, the Supreme Court said it, that the canons by which justice is delivered in our jurisdiction or dispensed in our jurisdiction is according to the constitution of the land, by way of practice, the rules of court, right, and established principles. Now, what was the basis, what was the authority by which, she decided to admit the tape? I am saying that this is a tape that squarely falls within Article 18.2 of the Constitution.
Private conversation.
Private conversation. Now, if you are going to admit it, you should come under the exception, right? And not solely because if it was offered by the accused.
Oh, I get the point you are making. That the basis of the admitting the tape is not clear.
It is not
for
clear.
the purpose of precedent.
Yes, for the purpose of precedent.
Because I get you.
Paul, the Attorney General is not an accused in this matter. And so it's not as if you are admitting it for the purposes of the prevention of crime. Right? So under which of the exceptions are you coming under? Because if you say that if the prosecution had offered it, you would have admitted it. And so if the defense is also offering it, you are admitting it. Very humbly and respectfully, I think it is simplistic. It is simplistic. The reasoning there, with the greatest of respect to her, it is not a criminal trial. An application has been brought for the AG, for the case to be dismissed, right? And the question is whether or not it is material for the determination of the application. It is not. And secondly, the circumstance of the recording, it was a private conversation. Thirdly, there's an exception by which such private conversation may be admitted. You have to then show us which of the exceptions you are coming under. She didn't show us. And so I think that the reason...
But that's the end of the tape. We're not going to hear any more from the tape?
I think that...
Now she's closed that...
If you move away from... mechanical side of it, which is the strictly legal sense of it. In a certain regard, I think it is. Now there is some enforcement on it. Right? A judge has expressed her opinion on the tape. She now finds that the Attorney General didn't request for the assistance of JAPA. Right? And so
that is clear. She made a firm determination.
In that regard, it is good for the Attorney General. However, she also makes a pronouncement. She also gives an advice to the Attorney General. Right? Which advice? Which advice, in my opinion, is also problematic. And so if she had not listened to the tape, right, all the comments that have come with it wouldn't have, come up.
The advice that he should
stop
coming to court.
Exactly. The advice, and then also the her opinion on what Mr. Dame is said to have done. The rule have gone to the Rule Forum, which is the General Legal Counsel, for the matter to have been properly.
But do judges give advice?
Yes, nothing stops them.
Advice?
But nothing stops them. But I think that this
published advice.
Nothing stops them. I mean, they make recommendations. The Supreme Court has on several occasions made recommendations.
Is that not in relation to consequential orders, these recommendations?
No. If you say consequential orders, then they are binding.
Okay.
Then they are binding.
Yeah, but the Supreme Court is able to, because of the kind of jurisdiction they have, the original jurisdiction, to interpret constitutional matters and also to resolve conflicts between constitutional bodies. Judiciary versus legislature versus executive. So they can make these advice.
Nothing stops a judge. Let me give you a good example. Let's say a family feud, right? Let's say a matrimonial matter.
Yes.
And then one of them is the issue of custody. And the judge has determined custody. But she thinks that there's a way things should be handled. A judge can give an advice.
But this particular advice is major.
The advice is major, and
it may be politically skewed.
Apart from the potential of it being politically skewed, I think that it impacts on the ethos of the Attorney General's power in the Constitution. Because if you say that the Attorney General should not be directly involved,
if you advise so,
you are advising so. Don't forget, all prosecutions under Article 88(3) of the Constitution is under the hand of the Attorney General. And so, how does he remove himself from it?
by not showing up.
By not showing up.
Showing up and
So
saying
you are
and not
comfortable-
saying much.
So you are comfortable with the AG directing from behind, but by not showing up. Because all prosecutions are in the name of the Attorney General.
For sure.
Yes. And so that advice is problematic. That advice also presupposes that you have now believed everything on the tape. Which is why I think that if the tape had not been admitted, because it is not admissible in my view, and secondly, the forum for determining so is not in the court, and thirdly, because it does not, or it wasn't material for the judge in determination of the application before him, I think that it would have helped all of us.
Party 88(3), please. 88 is the entrenched clause on the establishment of the office of the Attorney General, and 88(3) will tell us what lawyer Baffour is leading us to. Have you found Article 88? What's the title of 88? It should be the Attorney General. It's on the side of it. 88.
Yeah, the Attorney General.
Okay, so read the first one.
Be the first to know Nsem-Pii TV.